we're talking basic estate planning. We're not going to get into real fine details, but instead what we're going to look at are those things that a person might want to check out just to be ready for some of the contingencies that might arise. In fact, what's going to happen, we're going to talk primarily about what you see right here. So the power of attorney. Power of attorney is one of those documents that allows somebody else to sign your name. And again, we're going to get into more detail on all those, but as a basic starting point, you might ask, well, why would I need one? Well, you might need one if, for example, you got in a car accident. You're unable for any reason to sign your name. That power of attorney would allow your family to avoid the need for a legal guardianship proceeding. So power of attorney, good thing to have. Healthcare directive. The basis or basic need for a healthcare directive is in the event that you cannot talk to your healthcare provider. That's the key on this one. If you ever got to a point, you're in a coma, you can't talk, there are things that need to be done, decisions that need to be made, what do? Well, the healthcare directive is a way that you can authorize somebody else to help you with those decisions. And again, we'll talk in some detail, but you're going to find that you can, in that directive, give to your person, we call it the agent, give that agent the hints or even the directions as to what kind of things you would actually want. Asset ownership, big issue. And we do asset ownership, we talk about that because even as in this early stage, as you look forward, it's always good to know how the assets are owned, because how they're owned is going to make a difference in the event that you do die. And we'll talk again in detail about that. And then the will. A lot of talk about will. You're going to find a lot of attorneys say everybody needs a will. You're going to find that in our office, we don't necessarily mean that. Because what happens is, depending on how your property is set up, depending on how your beneficiary designations are made, you may find that you've covered all the contingencies and the will may not be as important as other things that you might be planning to do. So with that, let's dig into some of the issues that you might have. So lifetime planning, disability. So the question becomes, well, what if I become disabled? And I know everybody thinks, well, that happens to other people. Realistically, it does happen to people. I'll bet all of you know someone either in your family or in your friends or acquaintances, somebody where something happened unexpectedly and there was a need. So the financial supervision that we're talking about is issues such as property, finance. What happens if you become disabled and your house needs to be sold? Who can sign the deed? We'll talk about that. Healthcare supervision, we've talked about that a little bit. And the healthcare supervision gets back to that idea again, that if you're unable to talk to your doctor, how do you deal with that? And as I indicated before, I'll tell you what the option becomes. If you don't have something in place for financial planning and for healthcare planning, you're going to end up, or your family's going to end up, going to court, having a guardianship and a conservatorship appointed. And the problem with those is they become expensive. It involves a lot of moving parts, and we can talk about that. And then that other one, asset ownership. As we talk about asset ownership, it becomes so important to understand how your assets are owned, because how the assets are owned really is truly going to dictate what happens to those assets when you die. So let's start with the power of attorney. So what we call a durable power of attorney is an important document. Basically, it says this. Let's use my example. So my wife was named Patsy. So I sign a document and it says, I appoint Patsy as my power of attorney or as my agent. And then there's a listing. You'll see general powers plus. I will tell you that when I started practicing law many, many years ago, the powers of attorney were very short. A lot of them were probably 3/4 of a page. Now, if you look at a power of attorney, one that's drafted by a lawyer, even one that you take down off the internet, they're generally going to be 5 to 6 to 7 pages long. And the reason is that financial institutions, investment companies, the government, Everybody likes to be specifically named in that power of attorney, and they do get long. If you go to an attorney for a power of attorney, you may find that it's long. You may look in there, and some of those items maybe don't even apply. Maybe there's something in there about a farm program, and you say, well, I don't have a farm. Why do I need something like that? Well, we do powers of attorney, and we do them in a broad form. Having extra does not hurt, and actually it's more cost effective for the client if you've got that general form and everything isn't tailor-made. Now, the next line, that words of durability, very, very important. And the reason that's important is this, is that the years and years ago, if I made a power of attorney out and did it in favor of Patsy, and I did become disabled, that power of attorney automatically ended. And so the words of durability came in through the law. And the law said, here's the deal. If you make a power of attorney, and in the power of attorney, you say, this power of attorney remains effective in spite of my future disability, or words like that, that means exactly what it says, is that if you later become disabled, that power of attorney is still in effect. So stop and think about that. Usually we make a power of attorney for the reason of what? For those times when we're disabled. If you don't have those words of durability in there, and the power of attorney doesn't function or doesn't work, you've really wasted the power of attorney. And it does happen. I had an extended family situation actually several years ago where I put together a power of attorney with the words of durability. This power of attorney remains effective in the event of disability. And we had it all set up. And sure enough, it turned out to be an uncle and an aunt, very nice people. They went down to the senior center, and the senior center was having help the seniors out day, and somebody said, well, I can make you a power of attorney. For whatever reason, they prepared a power of attorney, and that power of attorney said, we revoke all prior powers of attorney. Well, that took care of the one I did, and it was a very nice power of attorney, except you know what? It had no words of durability. And what happened is about 6 months later, my uncle had a stroke. He couldn't do anything. And they took that power of attorney, that new one, to a bank, and the bank said, sorry, this one doesn't work. And they called me, of course, and they said, what can we do? And the problem is you can't do anything, because at that point, basically that ship had sailed, so to speak. So very, very cautious. If, especially an attorney who's doing it, I think is always going to have those words in there. Just make sure that if you're doing one on your own, if it's coming off the internet, make certain that it's got words, something to that effect. This power of attorney remains in effect in spite of my disability or my incapacity, or words like that. So again, what's the benefit? Look down at that third line. We avoid the guardianship. Because what happens is, if I've got a power of attorney and I have a stroke, I already have a document that allows somebody to make financial decisions for me. My wife can go down to the bank and sign things that need to be done. If the house needs to be sold, she can, with that power of attorney, sign the deed to sell the house and get the funds that we might need, maybe for hospitalization, medical care, nursing care, whatever it might happen to be. If you don't do that, you end up in a guardianship proceeding. Now, understand that if a guardianship happens, it's not the lawyers who are making up all this process. It's actually the legislature, and the laws set up to try to protect people who might be involved in a guardianship. And what they're looking for is this. In the old days, this is the old days even before me, it wasn't uncommon for what would happen is somebody might run to the courthouse, and maybe dad was slipping a little bit, and they'd run to the courthouse and they'd get an order from the judge, and the next thing that happened, dad was in a guardianship. And the law, the legislature decided that was unfair. So the system is now set up with all kinds of protections for, in my example, for dad. So what has to happen in a guardianship, you have to get an opinion from a doctor. You have to have, usually it's a social worker that goes and visits the person who might have the disability, and so that they can report back to the court and say, yes, judge, we believe there is a disability. And obviously the doctor is going to say the same thing. You have to have an attorney appointed for dad, in my example. And obviously the child who's doing this has their own attorney. Well, stop and think. Now we got two attorneys, a doctor and a social worker involved, all of whom are going to need to be paid. and you end up with a lot of extra expense. You end up with a lot of extra time. So I can tell you the power of attorney, in my experience, 99% of the time avoids problem. There are occasions, and usually what it is, I'm afraid, is if the family members start to fight. And one child says to a judge, you know what, that child with the power of attorney is taking advantage of dad and he's stealing his money. Well, then you're going to end up in court, and you should. But for most situations, you actually can avoid the guardianship, avoid a lot of expense, and that power of attorney is a very simple document to prepare. The gifts down there, you'll see those gifts under power of attorney. The reason I talk about that is most powers of attorney, the ones we do here in our office, they have a provision that authorizes the agent to make reasonable gifts, which could, under law and regulations, in other words, legally can make gifts which could protect property from additional expense, medical expense, nursing home care, things like that, done under the law in accordance with the timelines. And so those are typically going to be in a power of attorney. Down at the bottom, I point that out. Some of you may live near the edge, for example, maybe live near the Minnesota border. And what you're going to find is in some states, and Minnesota is one of those, the power of attorney in those states is actually a statutory form. North Dakota, we don't have a statutory form. So when you see a power of attorney that's done by a lawyer in North Dakota, that power of attorney has been drafted and created by that lawyer. I always tell people, if you see a power of attorney that looks like one that came out of our office, they copied it. And there's nothing, I'm not saying there's anything wrong with it, but understand everybody creates their own power of attorney as a lawyer. If you go across the border to the east in Minnesota, there's actually a form over there where it's basically check the box. I think it's a good situation. I'm not sure why North Dakota has not done it to this point, but if you do live in those other states, just remember you may have an option that's maybe a little bit easier than the power of attorney that we have in North Dakota. Now, that having been said, again, I don't want to discredit the option of the internet. If you pull one down from the internet, there's nothing that's going to make that illegal in North Dakota. It still works with, again, our caution, which is what? The words of durability. Make certain that they are in there. Okay, how about the healthcare directive? So the thing about the healthcare directive in North Dakota, there actually is a form that is suggested by the legislature, and it's a good form. It's a very good form, very extensive. There again, it's, I think the North Dakota form, if I recall, is probably about 8-9 pages long. It has all kinds of things in it. But the most important is what you do is you designate an agent. So in mine, I would say, I, Casey, designate Patsy to be my agent to make healthcare decisions when I cannot. Now, in the healthcare directive, in the same way that I should have talked about in the power of attorney, you can also designate successors. You can say, but if Patsy can't do it, then I designate, for example, my son Mark to be the agent under the power of attorney or under the healthcare directive. And so there's nothing wrong with doing that. In fact, I generally tell people or suggest to clients, it's a good idea. You never know what's going to happen. And remember what could occur is that if both Patsy and I are in a car accident and we're both disabled and we have not designated a successor on the power of attorney or on the healthcare directive, guess where we end up? Well, we end up in court again, because now we're going to need to go back to the guardianship and to that court proceeding to appoint the guardian. So it's always better, in my opinion, to do that. The healthcare directive, again, if you look at the North Dakota form, which again is a suggested form, very broad. It's going to talk about the treatment that you want, providers. It's going to talk about the provisions that we, in the past, have always referred to as the living will. So for example, the living will language that I referenced there is, what happens if I'm dying? And we're not talking here about I'm going to die in a year. We're talking about the doctor walks in the door and says to my wife, Patsy, you know, Casey will be lucky to live another 6 days. And that's the kind of thing that we're dealing with when we use that living will language. And so choices are going to be made. One is the machines. Do we want the machines? And in my healthcare directive, I can set it up. I can say, yes, I do, or no, I don't. There's in the ones that we do in this office, we use living will language that says, what about nutrition, forced nutrition, which typically is going to be what? It's going to be like a feeding tube. So do I want a feeding tube? And what the form says, it gives options. I mean, we're as lawyers, we're not directing you as to what you want to do or what you're going to do. We give options. And so in the options that we have, it will say subparagraph A says, I want the feeding tube. C says, I don't want the feeding tube. There's a B, which is kind of the in between. And B says, I want the feeding tube, but if it reaches the point where that feeding tube is no longer doing me any good, it's causing pain, my body's no longer assimilating the nutrition, or all that's happening is just making the process of dying last longer, then there's an authorization that says at that point, pull it, take the feeding tube out. There's another similar situation for what we call I want to say water liquids. So liquids, forced liquids. And so same kind of thing, same options. I want it, I don't want it, I want it unless it's not working. Or the other option of both of them, you could say, I leave that choice to my agent. I could say, you know what, I don't want to make the choice. I don't know what the situation is going to be, you know, a month or a year or 10 years from now. So I'm going to let my wife, Patsy, decide that because I trust her. But the most important thing here is that you're the one that's got the choice to make those. And then that's the document that's going to guide, in my case, my wife, Patsy. In addition, permanent unconsciousness. The situation there is that we understand that you could be permanently unconscious and not dying. Best example, some may remember the young lady down in Florida where she had, I can't remember if it was a stroke or what it was, but the doctors said she's permanently unconscious. She wasn't dying. The doctor said if we keep her hooked up to a feeding tube into forced liquids, she may live for another 20 years. Her husband said she would never want that. Her parents, you know, you understand, their parents. The parents said, oh, no, we want to keep her alive because maybe there's a chance she'll come out of it. That actually went through, I think, about 2 levels of the Florida court system. And finally, the judge decided that there was enough evidence from her conversations with her husband indicating that she did not want to be hooked up to the machines, that I believe the judge finally allowed the husband to disconnect or order the disconnecting of the machines. So the answer to that, of course, is what? If you've got it down in writing in a healthcare directive, you don't end up with that uncertainty that puts us all in a situation where we end up in front of the court or in front of the judges. So that's the healthcare directive. Now, one thing, let's do a little comparison here. Back here on the power of attorney, you can make that immediate. And typically that's what we do here in this office. In other words, when I say I appoint Patsy as my agent, she's got that power right now. Now, when you do that, you've got to trust. I trust Patsy. So it could even be something like this. Let's say I'm out of town on business and something needs to be signed down at the bank. I say, Patsy, with your power of attorney, could you go ahead and sign your name, but also then sign my name as my power of attorney. So she's got that kind of authority. When you look at the power of attorney, sometimes people, even clients, say, well, gosh, what if they steal from me? Well, the reality is if somebody's stealing from you, I don't care if they've got a power of attorney or they just live in your house and they take your checkbook, that's a crime. And so the agent under a power of attorney is bound by law to act in the best interests of the person who signed it. And so therefore you do have an obligation. Now in the power of attorney, there is an alternative. It's not one that we advise, but it is one that's available. And that's what we call springing. It's a springing power of attorney. Kind of a neat little word, but what it means is this. I sign a power of attorney to Patsy. Now that power of attorney is not effective right now, but what it does is it says in there, however, if I become disabled, then the power of attorney is in effect. Years ago, people did a fair number of springing powers of attorney. Now, much less used, and here's the reason. Just in the modern era, the question becomes, how do we show disability? a lot of times in those powers of attorney, it would say, upon receiving a written statement from my doctor that I am unable to transact my business, this power of attorney springs into effect. I'll tell you the practical problem. The reality is out there right now, it can sometimes be difficult to get a doctor to say that. Doctors, understandably, probably they're concerned, well, what if I say that Casey can't transact his business? Somebody takes over his business affairs and something goes wrong, and then they turn around and come back to me and say, you know what, actually, you shouldn't have signed that paper. And so just be advised that we do not advise the use of a springing power of attorney because it can be difficult to establish the disability. On the other hand, this healthcare directive, that only springs into effect if you cannot communicate with your doctor. There is no such thing as a current healthcare directive. It's not provided by the law. It's not going to be honored by a healthcare provider. So we do not deal with those. You know, one thing sometimes people talk about, and I just want to kind of dispel that real quickly. Sometimes people will be concerned about tax. They'll be concerned, well, what about the estate tax? What about inheritance tax? What happens if I don't plan my estate? Okay, look at that. Look at that screen, if you would, please. What you're going to see is a progression of protection. Now, that 3.5 million in 2009, just so you understand, that's a protection. That means if I died in 2009, in the total of all my estate, my house, my cars, you know, investments that I might have, my 401k, my IRAs, if you totaled everything together, and if it was less than $3.5 million, no estate tax was due. No estate tax was due. Now, the other thing to look, if you look at the top, it doesn't just say estate tax, it says transfer taxes. So what happens in the United States and actually in North Dakota is that there's a combination. So if we look to 2009, what that says is that even in 2009, if I had an estate of, let's say, $3 million, and I decided I don't need all that money, I'm going to give my kids $2 million, that 3.5 covers not only gifts, but also property at my death. And so what would happen is, if I gave away $2 million in 2009, that meant that on my death, I still have $1.5 million of protection because I've only used up 2 million of my protection. Now, for most of us, we're not all that concerned about it. If you look at 2010, just for a cute little part of history, what happened in 2010, Congress couldn't decide what to do. And there was a year in there where there was no tax. There was no estate tax at that time. So in other words, if you died on December 31 of 2009, the estate tax limit was 3.5 million. If I had a $5 million estate, that meant that my estate would pay tax on what? On the difference, the 1.5 million. But if I died on January 1 of 2010, no tax whatsoever. Now you can kind of get a sense of some of the decisions that probably were being made at the end of December in 2009. Same thing, you go to the end, think of 2010. So if I'm on my deathbed at the end of 2010, if I die before January 1, my estate doesn't pay any tax. If I die on January 1, then we go back to a $5 million tax. If my estate was $7 million, I always kid my kids or my children that on December 31 of 2010, I would have locked the door to the hospital room so nobody came sneaking in and took care of me to make sure that they didn't pay any tax. It was a bad situation as far as I'm concerned, but Congress did remedy it. Now here's the reality. Look down toward the bottom. You'll notice by 2022, the estate tax protection is now, at that point, was 12.06 million. It is now in 2023, they've recently established the new one. It's now $12.9 million. What that means is that any person dying in North Dakota or gifting for life, let's say I've got a $10 million estate. I give $5 million away to my kids. I still have $5 million in my name when I die. Both of those are under $12.9 million no tax due. But it gets better. That's per person. If I'm married, $12.9 million for me, $12.9 million for Patsy, I can promise you that the vast majority of estates in North Dakota will never pay either a gift tax or an estate tax, simply because those numbers are so high. Will notice in 2026, Congress, unfortunately, as dysfunctional as they seem right now, unless they can come together, agree to continue those protections, 12.9 million creeping up, who knows, by 2026, it might be up by probably $14 million. But if Congress doesn't act in 2026 to continue it, it'll roll back to that old version in 2017 when the tax law was changed of 5.49, but there'd be a cost of living increase. And we'll go away from this with the idea that either Congress continues it, in which case almost nobody will pay tax except maybe Bill Gates and some others. But even if it rolls back, it's probably going to roll back in the area of about $6 to $6.5 million. That's per person. That still gives a married couple $13 million of area to either gift or to transfer at death. And again, for almost all of us, we're just not concerned about estate tax anymore. And that's a good thing. That is a good thing. Asset ownership. Remember, I told you it's a big issue. It's a big issue. What's the difference? What are we talking about here? Well, the thing to remember is this, is that how you own property does make a difference. And when we talk about the will, you're going to see why. Okay, an example. Solely owned property. Maybe an easy one is, I'm a single person, I own the property myself. And so what's going to happen is when I die, that property is going to be covered by my will, because the will, as we're going to see in a couple slides, only covers solely owned property. Compare that to joint property. So Patsy and I, we own a house together. If I die, that house, because we own it jointly, that house goes automatically to Patsy. So I could have a will that says I give all my property to my kids. Not that I do it, but if I did it, all my property goes to my kids. Well, the house doesn't go to the kids. Why? Because in a joint tenancy, immediately upon death, the survivor becomes the owner. Now, again, why is that important? Well, again, if I make a will, let's say that what happens is that we have an issue where what you've done is you have set up your property in joint ownership with a child. We're going to see in the next slide, that's going to make a big difference as to how things work. Beneficiary designations. If you've beneficially designated property, could be a bank account, could be an investment account, probably your 401k, your IRA, your 403 account, whatever it might happen to be, those beneficiary designations take precedence over a will. So stop and think about that. So if Patsy and I have all of our property either in joint name, or if my retirement account designates her as the beneficiary, and there's nothing that's in my name alone, what's going to happen is upon my death, Patsy gets everything. She doesn't go through probate. She doesn't need to do anything. She takes for the joint house or the joint name in the house, real simple. She takes a certified copy of my death certificate, takes that to the county recorder, files it, all done. Beneficiary designations, she takes my death certificate, she hands it in, maybe fills out a beneficiary request form, all those come over to her. Everything's all finished. If I had held the house or held property in sole name, she might have been required to go through probate in order to make it all work. So, idea is this, most often I counsel, especially married couples, I say, unless you're dealing with a tax problem, which most of us won't, the best way, in my opinion, between a married couple who desire to have property go all over to the surviving spouse, either own it all in joint name or beneficially designate everything. And in that way, at the first death, the surviving spouse has no issues. Very, very, very simple. So what about some particular issues? What about these issues during lifetime? So, and obviously the lifetime is also when you get toward the point of death, what happens? Well, the vehicles, in your vehicles in North Dakota, the North Dakota Department of Transportation says this, is if you own a vehicle, let's use my example, if it says Casey and Patsy, JTWROS, which stands for Joint Tenants with Right of Survivorship. Upon my death, Patsy takes a death certificate to the department and the car automatically transfers over into her name. If on the car it says Casey and Patsy and nothing else, then the Department of Transportation has given the opinion that that means that Casey technically owns half the car, Patsy owns half the car, and in the event that I die, Patsy does have to go through some paperwork in order to get the property transferred into her name, or the house. I'm not the house, the car, Casey has to transfer the car into her name. My opinion, best way, and you probably have it this way, because this I think how most of the dealers are doing it, if you put an or. If it says Casey or Patsy, then what happens either during lifetime or upon death, either one of the owners can sign off. You don't need the signature from the other. So during my lifetime, we want to sell a car. I'm out of state. I say, Patsy, could you run down and sign the papers to transfer the title of the car? She can do it on her own. If I die, she has the right now, without doing any additional paperwork, to sign that deed over to a new purchaser. Bank accounts. Bank accounts are set up somewhat like that. What a bank account says, if that says Casey and Patsy, or if it says Casey or Patsy, on death, it automatically transfers to the survivor. It's that simple. Bank accounts, if you have additional owners, just remember what that does. So I use an example. Let's say that, let's say we've got mother, we've got a surviving mother, and we've got 2 kids. And what happens is, well, in fact, let's use my example. My mother's now passed, but I've got a brother, and my mother was living in Bismarck. I was in Bismarck. My brother lived down in Colorado. If, it didn't happen, but if my mother had put my name on her bank account, a lot of people do that. They say, well, you know what, just to make it easy, I'm going to put your name on the account. Okay, you can absolutely do it, legal to do it. But understand something. Remember that bank account, that line right above? If it says Mom and Casey, what happens on death? Well, on death, it becomes my bank account. So if Mom made out a will and said, on my death, I give all my property to my loving and wonderful sons, Casey and Jeff, in equal shares, remember what occurs. Wills only apply to solely owned property. The will doesn't affect that bank account. That bank account goes to me, my bank account. Jeff kind of has his hands up in the air. What's going on? And of course, the response is what? Well, Mom always did like me, Jeff. But it's not a good thing. I've had it happen many times. I can tell you in almost all instances, the child who got that bank account said, you know, Mom didn't mean that to be me. It's okay. I'm going to divide it out and distribute it among the kids. Think back, when you think of that, in the past, that became a big issue, but it's a gift. My half that I give to Jeff is a gift, but we don't have a problem because why? Because our transfer and gift taxes are so high that we don't need to worry about it, and it turns out not to be a concern. Understand, houses and land is that if you own property in your own name, and sometimes I see that, it could be that, let's say that one of the spouses, let's say that the wife inherited land from her parents. Typically, that's going to come down just into her name. It's not going to come down typically to the daughter and the son-in-law. They're going to transfer it to the daughter. That's just the way they do it. If the daughter dies, remember now, that is in her estate. That has to go through probate because she's the only owner, and solely owned property is covered by the probate process. So we remember that. Also, even during lifetime, Patsy and I have that house. Let's say we decide to sell it, or we're going to take an equity mortgage on it, whatever it might happen to be. Remember, if I'm out of town, just because Patsy and I are both on it, each of us has to sign. If I'm out of town, what's the answer? Remember back a few slides, the power of attorney. And she can be authorized to do those signatures. But somebody, I'm sorry, both, and if you got more, all owners are going to need to sign on that account. The death. So what happens on death is what's going to occur is, first of all, important, look at that top line. The power of attorney terminates. And I see this fairly often. I see people say, well, it's okay, you know, mom passed away, but I'm the power of attorney. No, it doesn't work. Immediately on death, that power of attorney terminates. Is probate needed? We've covered most of that. Solely owned property, if it's there, you're going to need to go into a probate. There's one issue here. If mom died and didn't have a house, or didn't own land, you know, maybe the house had been sold, she's living in an apartment. If her solely owned property is under $50,000, then there's a shortcut process that you can go through, so you don't need to go through the entire levels of probate. So you always look at that. A lot of times I'll find it maybe a bank account, maybe a car, and if it's under 50,000, we can do that in a very short process. And you're always looking then, how is the other property titled? Did I have a bank account just in my name? Did I have an investment account just in my name? And if the answer to any of those questions are yes, then you are going to end up going through a probate. And let's go to this kind of a summary sheet, which would be, or not summary, but this next jointly owned property, remember, no probate. Beneficiary designations, no probate. One option on land and houses is what we call a transfer on death deed. It's fairly new to North Dakota, kind of a new addition the legislature put in. And we, for example, Patsy and I we could make out a deed, even when we got jointly owned house. And maybe what we want to do is, we don't want to lose control of that house, but we would like to set it up so the kids don't need to go through a probate process in order to get the house transferred or sold. We in North Dakota can do a transfer on death deed, and the deed says something like this: Casey and Patsy transfer effective on death to the children, and then the legal description of the house. What that does in North Dakota, it says during our lifetime, we can sell the house, we don't need the kids' signatures. We can mortgage the house, we don't need the kids' signatures. We can even revoke it. You know, the kids act up, the children act up. We don't, one of them gets into trouble, we want to take them off the deed. We always have the right to alter that deed. But upon the second death, that property is going to automatically transfer down to the children, and all they'll need to do is go to the courthouse again, go to the recorder's office, put in a death certificate, and they are in business. So it's a great thing. The transfer on death deed, quite frankly, is the best, what I call it is the best alternative to the living trust, people doing living trusts. And nothing wrong with living trusts, but usually it was done for things like this. The trust would say, mom and dad are going to set up this trust, and they're going to be able to control it during their lifetime, and they can change it, and they can take money out, they can sell the property, but upon their death, the trust takes over and the property goes down to the beneficiaries. Well, for land, houses, buildings, things like that, this transfer on death deed does exactly the same thing, and it's good. It's a very, very good alternative. So let's go to wills. So as you've seen, as we've talked this through, the wills are going to act on that solely owned property. So let's use Patsy and I. So let's say that what happens is that as between the two of us, Patsy and I have it set up so the house is jointly owned, the vehicles are jointly owned, bank accounts are set up in joint name, retirement accounts, beneficiary designations, so that when I die, everything's going to Patsy. If I have a will that says I give everything to Patsy, it really doesn't matter because everything's going to Patsy anyway. It's all taken care of. It's on the second death that typically the will is going to take effect. So when we're dealing with clients in this office, we are usually in a situation where what we're advising the clients is that we're making out two wills because there's one for each of you. Obviously in a married situation, spousal situation, or with partners. And so what's going on is we've got these two wills. But in effect, I will tell clients, your goal is to set up so that on the first death, you don't need that will, because you've set everything by joint tenancy, by joint ownership and beneficiary designation, everything's passing over. Well, think about this. The survivor now is the sole owner of all the property. Upon my death, Patsy owns the house, she owns the cars, she's the sole owner of the bank account, the investment account, the retirement account. All of these things are now in her name. Now that will that we made up takes effect. And the will is going to say something like, a typical will might say, I give my entire estate. In fact, actually, let me back up. Usually the will say, if upon my death, everything to my spouse. Now remember, we took care of that. We got all that covered. But it also says then, however, if my spouse predeceases me, then I give my estate as follows. And typically an estate might say something like this. It might say, I give to my children in equal shares. And then there's a very cute little legal term called per stirpes, P-E-R-S-T-I-R-P-E-S. And what that means is that if we have 6 children and one of them dies, the share, that 1/6 share, will go down to any children of that deceased child. It kind of runs it down the bloodlines. But even in that case, the will is going to say is that, however, if a child dies before me without surviving descendants, then the distribution will be made in 5 shares to the surviving children. So that's typically the way that a will is going to work. You're going to name somebody to take care of things. In North Dakota, we call them the personal representative. Sometimes in other states, they call them an executor. That's an example. On the first death, you're going to say it's going to be my spouse. Again, understanding it's very probable that the spouse will never serve as a personal representative because it's not needed. But on the second death, you're going to designate probably a child. Sometimes it's good to have 2 children. In situations where maybe you're dealing with a blended family, very often it'll be 1 child from each side, just to take care of business and take care of things. So what are kind of some of the special items that you would put into a will? Well, if you still have minor children, or even if you have children who have their own children, would be your grandchildren, sometimes people will put into a will a provision that provides for a trust. So as an example, a married couple, at this point, Patsy and I, all our children are older, but we do have grandchildren, have some younger grandchildren. But let's say that it's a younger couple and you've got your own children. Well, typically what you're going to do is you're going to say in that will, I give to our children in equal shares. However, if any child is under, and I'm just going to pick an age, is under the age of 30 years, the share of that child is going to be held in trust, and it's going to be held for the benefit of that child until the child reaches the age of 30. Could be 25, 28, whatever you pick. And then the typical trust, at least the ones we use, are going to say something like this, is that hold it until the child reaches 30. However, if the child needs money for education, for healthcare, for anything like that, you go ahead and you pay it out. Anything that needs to be done for the best interest of that child. Then often what we do is we pick out what I call incremental distribution dates. You might say, again, remembering that trust is always available to help the child out, but you could say, and when the child reaches 22, transfer 10% of the trust balance to that child. When they get to be 26, transfer 50% of whatever's left over, and when they're 30, transfer the remainder. Sometimes people do it all at 22, sometimes that. I have clients who've decided the distribution won't take place until the child reaches the age of 55 years. Now, you may think that's really absurd, but what the parents are doing, they're basically setting up. They're saying, the children are doing okay, but that's going to be retirement money. And when they get to be 55, we're going to start to pay it out annually for a period of 10, 15 years. Actually, kind of makes sense. When we talk about a trust, understand that a trust does not always need to be run or administered by a bank. In fact, most of the trusts that I set up are actually set up for family members. If you, for example, if you had 3 children and you said in there that if one of the children dies, the property goes down to the grandchildren, to the descendants of that child, and they're underage, I will often have The remaining children serve as the trustee to watch over the assets for their nieces and their nephews. All kinds of options that you've got. Children with special needs. If there is a child in the family and that child has a special need, has an incapacity of some kind where they're eligible for government payments, you typically, you do not want to simply transfer that money out to that child. Instead, we put that money and those assets into a trust for the benefit of the child, so it can be used in a way that helps the child, enhances the happiness of the child, but does not disqualify the child for government benefits which they could receive. Special transfers, property transfers, a lot of times could be a business. And that's one thing, especially businesses and farms, that I really think an individual needs to pay attention to. One of the, I guess I'd call it one of the saddest situations that I see is maybe there were 4 kids. Mom and dad were on the farm. One of the children stayed back, and that child farmed, shoulder to shoulder with mom and dad for 30 years. And mom and dad either didn't have a will, in which case, if there's no will, and there are 4 kids and mom and dad's 4 kids, all the property is divided equally. Or they even make out a will, and maybe they're not thinking ahead, and they want to be fair to everybody, and they say, we give the farm, or we give all our property to the children in equal shares. Well, guess what? The child who spent the last 30 years on that farm, working the dirt and helping mom and dad out, now has partners. And those partners own as much of the farm, each of them 1/4, as the farmer child does, and that can create lots of problems. And quite frankly, creates even more problems when the in-laws, the brothers-in-law and the sisters-in-law get involved. Same thing with businesses. Cabins, how do you get to a point where you share a cabin? Maybe there's this great cabin on up at Sakakawea or down at Lake Chida, and everybody enjoyed it. Well, now upon death, there are 4, let's say there are 4 children, 4 own it equally. Is there going to be a plan in your will for how they're going to share the cabin? Those are the things to think about. Those are the things to think ahead about. Charities. In the past, charities in the will were an issue because the estate tax was much lower. Now, it really isn't that much of an issue, but do understand if you're going to give money to charity, you could either do it in the will, say I give $10,000 to the animal shelter and the remainder to my children, or another way to deal with it is sometimes it's very good to use IRA accounts, because remember, that's taxable money. And instead of sending the taxable money to the kids, take that $10,000 you were going to give to the animal shelter, designate $10,000 out of your IRA, because the animal shelter is nonprofit and does not pay tax. Last issue on signing the wills. Remember, you have to have mental capacity, no undue influence. If there's a will where basically one of the children is hovering over mom and dad or over mom, a lot of times it's the surviving parent saying, Mom, you got to do this, controlling mom, that will probably isn't going to work. But it's tough to prove. Just be honest, it's very, very tough to prove. Needs to be signed by 2 witnesses, or in North Dakota, it can be notarized. We now allow a notarized will to be effective. The important thing about a will to remember, you can always amend it. If you make that will out down the line, you change your mind. You add a grandchild with special needs and you want to provide for that grandchild, you can always amend a will. And the last question there is, where's the original? Where's the original? It's always good to keep track of that original so you know what's going on. So that, again, I call it a quick summary of basic planning issues that could affect you right now. Nobody likes to think of these events occurring, not only a death, but all of a sudden a disability or an incapacity. But you know what? If you've been behind our desk back here, and you've seen it enough times, you realize how important it can be to do it. So the bottom line is, remember, you make a plan. That's what it's about. If you understand where property is going, that's the most important issue. And with what the things that we've talked about, you understand what is solely owned property, jointly owned property, beneficiary designations. Those are the kinds of things.